Good morning. I'd like to call the Tennessee Advisory Council on Workers' Compensation meeting to order. It's February 29th, 2016. Madam Secretary, please call the roll.
Carrie Dove.
Here.
Bruce Fox.
Here.
John Garrett.
Here.
Bob Pitts.
Here.
Gary Selvey.
Here.
Paul Schaefer.
Here.
John Burleson. Jason Denton.
Here.
Sandy Fletchall. Dr. Graves. Abby Hudgens. John Harris.
Here.
Lynn Lawyer. Jerry Mayo. Dr. Merle. Greg Ramos. Mike Shinnick. Chairman Eldridge. You have a quorum via telephone.
Thank you. I'd just like to take a brief moment to introduce myself. My name is Allison Cleaves. I'm an Assistant General Counsel with the Department of Treasury, and in the context of this meeting, I serve as a Treasurer's designee. He sends his regards and his regrets. He is in Washington, D.C. this week. Before we get into the substance of the meeting, we have one housekeeping measure, and that is to vote on a necessity statement. Because a quorum of the members of this body will be participating electronically or by teleconference, this body by statute must vote on and approve a necessity statement that must be contained within the minutes of the meeting. With that, I hand it over to Ms. Schroeder to read the resolution, at the conclusion of which the chair will entertain a motion.
This council is statutorily required under Tennessee Code Annotated 50-6-121 to make recommendations to the Senate Committee of Commerce and Labor and the House Committee and Subcommittee of Consumer and Human Resources relative to workers' compensation legislation. The council needs to opine on Amendment 12479 to House Bill 2038, Senate Bill 1088, which will be considered by the Senate Committee tomorrow, March 1st, 2016. Because the council needs to make a recommendation about this amendment before tomorrow, before the committee meeting, a physical quorum of council cannot meet in time, thereby necessitating this teleconference meeting.
Do I have a motion to approve this necessity statement as the reason for conducting this meeting by teleconference?
So moved.
I have a motion. Do I have a second?
Second by Paul Schaefer.
Thank you. I have a motion and a second. Any discussion? Hearing none, Madam Secretary, please call the roll.
Carrie Dove.
Aye.
Bruce Fox.
Aye.
John Garrett.
Aye.
Bob Pitts.
Aye.
Gary Selvey.
Aye.
Paul Schaefer.
Aye.
It's unanimous.
We are here. We have convened this council to discuss the amendment to Senate Bill 1880 and House Bill 2038, and the barcode on the amendment is 012749. Oh, you do the minutes. Oh, I'm so sorry. I apologize. Excuse me. Okay, next on our agenda, I apologize for that, are your draft minutes. Do all of you have a copy of the draft minutes? And this is from what meeting? The February 22nd, 2016 meeting. Do I have a motion? I have a motion to approve. Do I have a second?
Second, Gary Selvey.
With a motion and a second, do I have any discussion? Hearing none, Madam Secretary, call the roll.
Carrie Dove.
Aye.
Bruce Fox.
Aye.
John Garrett.
Aye.
Bob Pitts.
Aye.
Gary Selvey.
Aye.
Paul Schaefer.
Aye.
It's unanimous to approve the minutes.
Now we're back on your legislation, which is the purpose for this meeting. We're back on Senate Bill 1880, House Bill 2038, and its amendment with a barcode of 012749. Is there anyone who wishes to speak relative to the amendment? Yes.
Thank you, Madam Chairman. This is the bill that I'm actually carrying, and the amendment actually writes the whole bill, makes the bill, because it was just a caption bill till we got all the language together. And I know, pending questions right now, that we do have somebody who want to speak on this bill, and I'd call my legal counselor, Troy, if he would come forward, with your permission.
I'm Troy Haley, Bureau of Workers' Compensation. And I just wanted to point out on the front end, there's a little bit of confusion, I think, about this being an administration bill. This is actually not an administration bill. We have worked with the sponsors of this bill and with some constituent groups to try to clarify the language and be happy to work with them. We're certainly will defer to the will of the legislature on this, but this is not actually a governor's administration bill. And my understanding of what the language is, though, is it would authorize the administrator and the Bureau of Workers' Comp to promulgate case management rules and also rules for insurance adjusters. We'd also we've got some rules that are already in process on case management and on insurance adjusting, but we need some legislative authority to proceed on that. So be happy to entertain any questions. All right, thank you.
Do any of the council members participating by teleconference have any questions for Mr. Haley? Yes. I believe, Mr. Bromell, you wanted to speak, you indicated?
Yeah.
And is it proper for me to speak, or the sponsor of the bill need to be heard first? I'll be happy to address the issues I have.
Be glad to hear from you on this, and I was just kidding a while ago when I said it was an administration bill. I said you need to go talk to the governor, but I was just trying to get some traction out of you. And you know, normally we're on the same side on most of these issues, and both of you are my good friends. And I think probably your concern with the bill, that and I want to hear all your concerns, and it may be something that we can work out. But it probably has to do with the fact that we're applying it to third-party administrators. Is that true?
Yeah, we support the intent of your legislation. I understand what you're doing, Mr. Chairman, and if I may address the council on that.
Please do.
The insurance industry currently is spending 69 cents out of every dollar, every claims dollar on medical benefits, and that leaves 31 cents for indemnity to injured workers. So I don't think anyone can say we're not spending enough money on medical benefits, and we share the chairman's concern expressed in this bill that those benefits be delivered timely and in a proper fashion. I think, and I was here when Mr. Gill testified, it seemed like there may be one or two bad apples that are in the industry that need some attention and frankly need to be sanctioned. But what I'm here today to say is that the idea of certification for case managers and their assistants, whoever their assistants may be, it seems to be going a little bit too far. And I think, I know that Ms. Hudgens has rules now at the Attorney General's office dealing with case management. She's done a great job with treatment guidelines. A lot of attention has been spent on benefits for the injured worker. So my suggestion is to see if that works and what effect that has, and then come back later if we need further legislation. But I would suggest at this time that this legislation may be expensive and cumbersome to train and certify case managers, there's not a demonstrable need to do that. I think the need lies in sanctioning the people who are not doing right, and we support that. As a final comment, the amendment, as I read it, becomes effective upon becoming law, and if we have this certification, we would need quite some time for everybody to become compliant and for the Bureau to come up with a certification program. So I'm not sure that the immediate becoming a law fits with what we're trying to do here. And I'll be glad to answer any comments that you have.
Ms. Hudgens.
Thank you, and let me just respond to your thoughtful comments, and I appreciate the input. Let me give an overall generalization to really rebut something you said, which was one or two bad apples. The reason we began developing guidelines and rules for case management was not because there were one or two bad apples, but more that there was an uncomfortably large trend of the role of case manager and the role of claims adjuster becoming blurred. That is, we got more and more complaints about case managers who are being required to do those things a claims adjuster would do in order to get the work to be a case manager. Because of the pervasive nature of that, we were very concerned, which led to the rules we were promulgating and have already promulgated. When it was in the Attorney General's office, there was the statement made that to have a penalty, which of course gives teeth to be able to get compliance with the rules, needed legislation. So the rules have already been promulgated. There have been public hearings. There's adequate time for people to get that certification. We put more time in it as regard to the assistant case managers and the certification process. So while the law will go into effect upon signing, the rules that have already been developed provide enough time for case managers to get the necessary certification. There's a phase-in period. As to the rules regarding not public, but claims adjusters, again, it is a problem that has been pervasive that we have seen. There certainly are good third-party administrators, and a good third-party administrator may have good and may have not so good claims adjusters. But when we analyze the system, the problems that we see that are causing more cost for both insurance companies and for employers is because of the excessive hoops that everyone must go through to get a claim processed. So my contention is that in the long run, health care provision will be better, claims will go more smoothly, and there may be less adjustment cost if we can get everybody on board with good practices. Thank you.
Yeah, and Ms. Hudson, we agree with your authority to promulgate those rules, and glad that you did, and we participated and certainly will comply with them. But as you said that, it occurred to me that hopefully those rules will obviate the need for further legislation in the area. And that was my concern.
I think we all know that rules that are on the books without any enforcement mechanism are very easily ignored.
I understand. That's all the comment that I had, unless there are other questions. All right, thank you. And thank you, Mr. Chairman. I always hate to be on the other side of legislation from our chairman, but that's how it is. Thank you.
Madam Chairman, I would like to ask Abby 2 or 3 questions. As I understand the situation before us, the bill that is being proposed basically does not establish any new authority or get you in any areas that had not been previously contemplated under the rules that have been through public hearing, with the possible exception of having the authority to do penalties. Is that roughly correct or incorrect?
The rules on case management included penalties, so it was certainly contemplated. It was with advice of the Attorney General's office that we learned that we could not use penalties without legislation. Now, the same would apply on the claims adjusters issue.
So roughly speaking, my summation was pretty much correct. Thank you.
Yes.
With that understanding, I would move that the bill be recommended
But
with
before we
pass.
make a motion, I believe that there was somebody else in the audience that wanted to speak. I got a wave from Mr. Everett Signer, who indicated he would like to speak. If that's the will of the body, to have one other, thank you.
I'll withdraw the motion.
Good morning. Everett Signer with Brookwood Services, and I appreciate the opportunity to speak before the council. Dave made a lot of good points, and I too appreciate the Bureau's efforts with respect to case management rules. I think that the Bureau has identified a problem that they believe that needs to be addressed, and we certainly respect that. And I was present at the rulemaking hearing. It's been a few months, couple, 3 months since that time. And so the Bureau took the comments of some of the interested persons there, specifically from Essential and some others. So again, appreciate that and appreciate their efforts. Brentwood Services is a third-party administrator. We employ claims adjusters. And so it's when we see any sort of an effort to determine how those persons ought to be regulated, it's certainly something that we want to get involved with. Right now, we are a licensed entity with the Department of Commerce and Insurance. We already are licensed by a department. That department can take enforcement action against us if we do something wrong. Now, not all TPAs, because the TPA rules only apply to TPAs who handle self-insurance clients, the Department of Commerce and Insurance is only empowered to regulate those entities. From what I understand, that is almost every single TPA which is involved in the state, because there are a lot of self-insured employers in the state of Tennessee. So one of the things that's from the get-go concerns us is that we're going to have enforcement authority in two different departments, and I think that that's something which concerns us. It's something which concerned us when the silent PPO legislation was being debated, and the way that we determined that would be handled was if you're licensed by the Department of Commerce and Insurance, enforcement is handled at that department. If you are not licensed by the Department of Commerce and Insurance, enforcement is handled by the Bureau, and that was something which we, on the payor side and also the provider side, agreed upon at that time. So we would respectfully request that that same sort of thinking be reflected in this legislation. Now, I apologize. This amendment was drafted last week, and so I've not really had a chance to even look at it in detail, but my understanding is that it creates enforcement at the Bureau for claims adjusters who are employed by TPAs. So again, that concerns me. And I do think Dave brought up a good point, and that is we don't want to be penalized for when some of our competitors do something wrong, okay? Because one of our competitors may have done something really bad, all of us have to get our claims adjusters licensed, and we don't think that that is fair and reflects something which ought to be good public policy in this state. That doesn't mean that every adjuster that Brentwood Services employs is a good adjuster and follows the rules, But the majority, as you can understand, being a Tennessee-based company, the majority of our adjusters are based, in fact, all the ones are based in Tennessee and are very familiar with Tennessee rules. And so it doesn't seem like it'd be appropriate to place the same sort of burden on someone like us as opposed to someone, a national company, who has someone in an office in Atlanta who does Tennessee claims every now and again. So I bring that to the council's attention for consideration.
Hutchins.
Let me clarify a few points. You mentioned about your adjusters should not have to be licensed. This does not anticipate licensing. We did talk over a year ago with the Department of Commerce and Insurance, and it is our understanding that they do not have any rules that apply to the individual work of individual claims adjusters, and we are in the process of a collegial formation period on the rules. I believe someone from your office is participating in that. We are only trying to look at best practices. There should be no burden on you if you're following best practices. We're talking about certification, and we're talking about penalties for egregious acts. So as long as Brentwood Services is not looking for protection for egregious acts, there should be no additional cost on you all. While there are a good many TPAs that deal with self-insured employers, there are also an awful lot of insurance companies who have claims adjusters. You know that we are in a constant search for ways to make the workers' comp system as efficient as possible and to reduce the friction in the system that cost employers and insurers and ultimately employers money that's not necessary. And over time, a number of these practices have come into the system. So what this is a pathway to make the system work better for everyone.
And I certainly appreciate that, and I really do appreciate the Bureau's efforts to modernize and make the system more efficient. Let me make a couple of points if the chair lady is okay with that. A couple of things. First of all, as I understand it, there are already claims handling standards by rule which have been adopted by the department, well, formerly the Department of Labor and Workforce Development, now the Bureau. So as I understand it, those standards, at least as initially, it's been a while, but they're there. The second thing I would say is that there is currently enforcement authority at the Department of Commerce and Insurance for the prompt and fair handling of claims. And it's not just limited to their rules, the Commerce and Insurance Department's rules. It's any rules which a payor or a TPA are subject to. So I might respectfully suggest that there may already be the authority to handle this with the laws that currently exist. I certainly understand the position the Bureau is in wanting to make sure that they have the authority to do it, but I just might, again, I've just gotten this within the last week and have not had a chance to study it to see what sort of a problem is being addressed specifically. So I apologize to the Bureau for that, but we just respectfully suggest that be looked at.
There is a section that deals with claims handling practices. It is, as you sort of alluded to, very much outdated and does not address the problems that we see in the system. And as I mentioned to Mr. Brumell, talking about the case management rules without any enforcement power just sit there and gather dust on the shelf.
I certainly appreciate that. Thank you.
Thank you. Is there anyone else in the audience who wishes to speak on the amendment? Is there anyone on the phone, any of the members on the phone who wish to speak? Hearing none, the chair would entertain a motion.
Madam Chair, I would start with the belief that if there are any major heartburns between the Department of Commerce and the Bureau, they have either worked them out or they'll find a way to work them out. With that, I renew my motion for the bill to come out with approval of the council.
I have a motion. Do I have a second?
Second.
I have a motion.
Bruce Fox.
I have a motion. I have a second. Is there any discussion? Hearing none. Madam Secretary, please call the roll.
Carrie Dove,
Aye.
Bruce Fox,
Aye.
John Garrett,
Aye.
Bob Pitts, Gary Selvey,
Aye.
Paul Schaefer.
Aye.
It's unanimous.
Is there any other business to come before this body? Hearing none. I have a motion to adjourn from Mr. Pitts. Do I have a second? Oh, okay.
One of you folks on the phone second the motion to adjourn.
Second. Second.
Second. All right. Without objection, we're adjourned. Thank you for those who appeared on the phone. Thank you.